Between Parts Ill and JV, P455, dissenting view in the bank nationalization case, Afin Ped Fn Rana vi Zur. State of Gujarat, 1964. 5. SCR 294, and Sinantli v. State of West Bengal, ALR 1971, SC 961, referred to the pre-eminent feature of Article 31C is that it prot-q only law. Law in Article 31C must have the same meaning as it bas in other articles generally, namely a statute passed by the legislature. The article is inextricably bound up with Article 39B and C, because the purpose and the phraseology in both the articles are essentially identical. Law contemplated in Article 31C will operate on the ownership and control of the material resources of the community to be distributed as best TCT subservici commerlan good. In order to decide whether a statute is within Article 31C, the court may examine the nature and character of legislation and the matter dealt with as to whether there is any nexus of the law to the principles mentioned in Articles 39B and C. If it appears that there is no nexus between the legislation and the objectives and principles mentioned in Article 39B and C, the legislation will not be within the protective umbrella. The court can tear the veil to decide the real nature of the statute if the facts and circumstances warrant such a course. 450, 451, 452. The motion for accepting Articles 14, 19, and 31 from Article 31C is the same as in Article 31A. The exclusion of Article 14 is to evolve new principia of equality in the light of the directive principles. The exclusion of Article 19 is on the footing that laws which 8-1 have effect to directive principles will constitute reasonable restrictions on the individual's liberty. The exclusion of Article 31(2) is to introduce the consideration of social justice in the matter of acquisition. Directive principles are not limited to agrarian RCFOMU. Directive principles are necessary for the uplift and growth of industry in the country. Article 31C creates a legislative field with reference to the object of legislation. The article substantially operates in the same manner in the industrial sphere. Article 31A operates in the agrarian sphere. The problem arc, similar in nature though of die rent magnitude. The article is an application of the principles underlying Articles 31.4 and 31.6 and 31A to the sphere of industry, P453. On removing restrictions of Part Ill in respect of a law under Article 31C, there is no delegation of any power to amend the Constitution MATR of the 25th. Amendment the existing legislative field is read from the fetin of some provisions of Part 3 on the legislative power. A class of legislation can be identified and the legislative field can be carved out from the Pirat Lolar of fundamental regu, or some of those can be excluded by a provision of the Constitution. The entire process of the legislative field from the oration of some of the articles relating to fundamental regu is the Mandau, the Constitution, 453, 454. The successive amendment of the Constitution Morty carried out the principle embodied in Article 31 clauses 4 and 6 that Pialioa designed to secure public good and to implement the defecti. It unaltered Article 39B and AC would have priority over individual rights and cultal T1 FCRC fundamenter. Rights were to be suborcum to oidic 12 OIS, UP4 Kesavananda Bharati. Rala 33 de inclusiven of the declaration ini, adopted by the 25th Amendment in a law unda Article 31C, is to be appreciated in the entire context of Article 31C. The declaration is for the purpose of excluding the process of evaluation of legislation on a consideration of the virtues and defects, with a view to seeing if the laws have led to the result intended. If a question arises as to whether a piece of legislation with such declaration has nexus with the directive principles in Article 39B and C, the court can go into the question for the purpose of identification of the legislative measure on a consideration of the scope and object and pith and substance of the legislation, pp. 458, 459, State of West Bengal ver. Bella Banerjee, 1954, SCR 558, Dwarkadas Srinivas V. Sholapuris P. Gilgakoaldi, M54, SCR 674, Babu Bark Thakur v. State of Bombay, 1961, SCR 128, and SMT, Somavanti LT Orsav, the State of Punjab, 1963, SCR 774, referred to the inclusion of KIRA, Act 35 of 1969 in the KIRA, Act 25 of 1971 in the 9th Schedule by the Constitution. 29th Amendment Marat U valid Article 31B is independent of Article 31A, Matthew, are concurring. The validity of the 29th Amendment lies within narrow Compa 9S. Article 31B has LFC NFLD by this court to be a valid amendment. It has also been held to be an independent provision. The article has no connection with Article 31A, and therefore the contention cannot be accepted that before the acts can be included in the 9th Schedule,